The name of the book is Business Law. It was published by MC Kuchhal in the year 2016. This subject is mainly studied in BCom program first year, second semester, chapter 3. Consideration. Consideration is one of the essential elements of a valid contract. It is an important element, for it imports in a measure the safeguard of deliberation. The fact of its existence serves to distinguish those promises by which the promisor intends to be legally bound from those which are not seriously meant. The breach of a gratuitous promise cannot be redressed by legal remedies. It is only when a promise is made in return of something from the promisee that such promise can be enforced by law against the promiser. This something in return is the consideration for the promise. In the language of purchase and sale, Pollock has observed, I quote, "Consideration is the price for which the promise of the other is bought," unquote. Thus, consideration is the very foundation of a contract. Subject to certain expectations, agreements without consideration are void. Definition. Section 2D of the Indian Contract Act defines consideration as follows. When, at the desire of the promisor, the promisee or any other person has done or obtained from doing, or does or abstains from doing, or promises to do or to abstain from doing something, such act or abstinence or promise is called consideration for the promise. An analysis of the above definition will show that it consists of the following four components. First, the act or abstinence or promise which forms the consideration for the promise must be done at the desire of the promiser. Second, it must be done by the promisee or any other person. Third, it may have been already executed or is in the process of being done or may be still executory. Fourth, it must be something to which the law attaches a value. Illustrations. First illustration. A agrees to sell his house to B for rupees 10,000. Here B's promise to pay the sum of rupees 10,000 is the consideration for A's promise to sell the house, and A's promise to sell the house is the consideration for B's promise to pay the sum of rupees 10,000. Second, A promises to maintain B's child and B promises to pay rupees 1,000 yearly for this purpose. Here, the promise of each party is the consideration for the promise of the other party. Third, A promises his debtor B not to file a suit against him for 1 year on B's agreeing to pay him rupees 100 more. The abstinence of A is the consideration for B's promise to pay. And fourth, A promises to type the manuscript of B's book, and in return B promises to teach A's son for a month. The promise to each party is the consideration for the promise of the other party. Essentials of a valid consideration. The four component parts of the definition of consideration given above may well be described as the essentials of valid consideration. We shall now discuss these elements one by one in detail. First, consideration must move at the desire of the promiser. In order to constitute legal consideration, the act or abstinence forming the consideration for the promise must be done at the desire or request of the promise. Thus, acts done or services rendered voluntarily or at the desire of the third party will not amount to valid consideration so as to support a contract. The logic for this may be found in the worry and expense to which every one might be subjected if he were obliged to pay for services which he does not need or require. Illustrations: A sees B's house on fire and helps in extinguishing it. He cannot demand payment for his services because B never asked him to come for help. It must be noted that this essential does not require that the consideration must confer some benefit on the promisor. It would be enough if the act or forbearance or promise constituting the consideration was done or given at the promisor's request, the benefit made secure to a third party. Illustrations: B requests A to sell and deliver to him goods on credit. A agrees to do so provided C will guarantee the payment of the price of the goods. C promises to guarantee the payment. The contract between A and C is a contract of guarantee and is perfectly valid through the benefit which A confers in return of C's guarantee. C's guarantee is conferred not on C but on B, that is, in the shape of sale of goods on credit. A's promise to deliver the goods is the consideration for C's promise of guarantee. Second, consideration may move from the promisee or any other person. The second essential of valid consideration, as contained in the definition of consideration in section 2D, is that consideration need not move from the promisee alone, but may proceed from a third person. Thus, as long as there is consideration for a promise, it is immaterial who has furnished it. It may move from the promisee or from any other person. This means that even a stranger to the consideration can sue on a contract, provided he is a party to the contract. This is sometimes called as doctrine of constructive consideration. The leading case of Chinnaya versus Ramaya provides a good illustration to the point. Illustration: in the above case, an old lady, by a deed of gift made over certain property to her daughter R, with a decision that the daughter should pay an annuity to A's brother C, as has been done by A. Accordingly, to the same day R, the daughter, executed a writing in favor of her maternal uncle C, agreeing to pay the annuity. Afterwards, she declined to fulfill her promise, saying that no consideration had moved from her maternal uncle, that is the promisee. It was held that the words "the promisee or any other person" in section 2D clearly shows that a stranger to consideration may maintain a suit. Hence, the maternal uncle, though a stranger to the consideration, as the consideration indirectly moved from his sister, was entitled to maintain the suit. In the above case, it will be observed that although C, the maternal uncle, was a stranger to the consideration, he was not a stranger to the contract, as there was a separate contract between him and R, the daughter. The maternal uncle could not have sued on the basis of gift deed executed by A in favor of R, because he was not a party to it. A stranger to a contract cannot sue. A person may be a stranger to the consideration, but he should not be a stranger to the contract, because privity of contract is essential for enforcing any of the rights arising out of the contract. It being a fundamental principle of the law of contracts that a stranger to a contract cannot sue, only a person who is a party to a contract can sue it. Thus, where A mortgages his property to B in consideration of B's promise to A to pay A's debt to C, C cannot file a suit against B to enforce his promise, C being party to the contract between A and B. Iswan Pillai versus Soniveru. Exceptions. The above rule that a stranger to a contract cannot sue is subjected to the following exceptions. When an express or implied trust is created, in case of a trust, the beneficiary can sue his own right to enforce his rights under the trust, though he was not a party to the contract between the settlor and the trustees. Illustrations. First illustration. A transfers certain properties to B to be held by B in trust for the benefit of M. M can enforce the agreement, that is trust. M.K. Rapai vs. John. Second illustration. An addressee of an insured article is entitled to sue the post office in case of loss, as on receipt of such article the post office becomes in law a constructive trustee for the addressee. Family settlement. When a provision is made in a partition or family arrangement for maintenance or marriage expenses of female members, such members, though not parties to the agreement, can sue on the footing of the arrangement. Illustration. A daughter along with her husband entered into a contract with her father whereby it was agreed that she will maintain her mother and the property of the father will be conveyed to them. The daughter subsequently refused to maintain the mother. On a suit, it was held that the mother was entitled to require her daughter to maintain her, though she was a stranger to the contract. When the defendant constitutes himself as the agent of the third party. Thus, if A receives some money from B to be paid over to C and he admits of this receipt to C, then C can recover this amount from A, who shall be regarded as the agent of C. In case of agency, where a contract is entered into by an agent, the principal can sue on it. In case of assignment of rights under a contract in favor of a third party, either voluntarily or by operation of law, the assignee can enforce the benefits of the contract. Example, the assignee of an insurance policy or the official assignee on the insolvency of a person can sue on the contract even though originally they were not parties to it. Third, consideration may be present, past, or future. The words has done or abstained from doing, or does or abstain from doing, or promises to do or abstain from doing, used in the definition of consideration clearly indicate that the consideration may consist of either something done or not done in the past, or done or not done in the present, or promised to be done or not done in the future. To put it briefly, consideration may consist of a past, present, or a future act or abstinence. Consideration may consist of an act or abstinence. Consideration may consist of either a positive act or an abstinence, that is, a negative act. Thus, an agreement between B and A, under which B, on falling to pay debt amount on the due date to A, promises to raise the rate of the interest from 9% to 12% in consideration of A, promising not to file a suit against him for another 1 year, is a valid contract. A's abstinence being the consideration for B's promise. Past consideration. When something is done or suffered before the date of the agreement at the desire of the promisor, it is called past consideration. It must be noted that past consideration is good consideration only if it is given by the promisee at the desire of the promisor. Illustrations. First illustration. A teaches the son of B at B's request in the month of January, and in February B promises to pay A a sum of rupees 200 for his services. The services of A will be past consideration. Second, A lawyer gave up his practice and served as manager of a landlord at the latter's request, in lieu of which the landlord subsequently promised a pension. It was held that there was good past consideration. Present consideration. Consideration which moves simultaneously with the promise is called present consideration or executed consideration. For example, A sells and delivers a book to B upon B's promise to pay for it at a future date. The consideration moving from A is present or executed consideration, since A has done his act of delivering the book simultaneously with the promise of B. It should, however, be noted that it is said to be present consideration when at the time of the agreement it is executed on one side and the executory on the other. If both parties have done their part under the contract, example, where A sells a book to B and B pays its price immediately, it is a case of executed contract where nothing remains to be done, and not of executed or present consideration. Future consideration. When the consideration on both the sides is to move at a future date, it is called future consideration or executory consideration. It consists of an exchange of promises, and each promise is a consideration for the other. For example, X promises to sell and deliver 10 bags of wheat to Y for rupees 6,500 after a week, upon Y's promise to pay the agreed price at the time of delivery. The promise of X is supported by the promise of Y, and the consideration is executory on both the sides. It is to be observed that in an executed consideration, the liability is outstanding against only one side, whereas in an executory consideration, it is outstanding on both the sides. Fourth, consideration must be something of values. The fourth and the last essential of valid consideration is that it must be something to which the law attaches a value. The consideration need not be adequate to the promise for the validity of an agreement. The law only insists on the presence of consideration and not on the adequacy of it. It leaves the people free to maintain their own bargains. Thus, where A agrees to sell his motor car worth rupees 50,000 for rupees 1,000 only, and his consent in free, the agreement is a valid contract, notwithstanding inadequacy of the consideration. However, if the consideration be grossly or shockingly inadequate, and if one of the parties to the contract alleges that his consent was obtained by fraud, coercion, or undue influence, the court will treat inadequacy of consideration as an evidence in support of such allegations and will declare the contract void. Consideration must be real. Though the consideration need not be adequate, it must be of some value in the eye of law. That is, it must be real and competent. Where consideration is physically impossible, illegal, uncertain, or illusory, it is not real and therefore shall not be a valid consideration. First, physically impossible. A promise to do something which is physically impossible, example, to make a dead man alive or to run at a speed of 100 kilometers per hour, does not form a valid consideration. Second, legally impossible. A promise to do something which is illegal, example, a promise for illegal cohabitation, does not amount to good consideration. Third, uncertain consideration. A promise to do something which is too vague and uncertain, example, a promise to pay such remuneration as shall be deemed right, is no consideration in the eye of law. And fourth, illusory consideration. Again, an illusory or deceptive consideration does not amount to a valid consideration. Consideration is illusory if it consists in a promise to perform a public duty or to perform a contract already made with the promisor. Illustration. C. The plaintiff receives a subpoena, a kind of summon to appear at a trial as a witness on behalf of G, the defendant. G promised him a sum of money for his trouble. On default by G, C filed the suit for the recovery of the promised sum. It was held that C, being under a public duty to attend and give evidence, there was no consideration for the promise and hence the promise is unenforceable. Exceptions to the rule: no consideration, no contract. Consideration being one of the essential elements of a valid contract, the general rule is that an agreement made without consideration is void. But there are a few exceptions to the rule, where an agreement without consideration will be perfectly valid and binding. These exceptions are as follows. First, agreement made on account of natural love and affection. An agreement made without consideration is enforceable if it is first expressed in writing and second registered under the law for the time being in force for the registration of documents. Third, made on account of natural love and affection. Fourth, between parties standing in a near relation to each other. Thus, there are four essential requirements which must be complied with to enforce an agreement made without consideration. Illustration. First, A promises for no consideration to give to B rupees 1000. This is a void agreement. Second, A for natural love and affection promises to give his son B rupees 1000. A puts his promise to B into writing and registers it. This is contract. It should, however, be noted that mere existence of a near relation between the parties does not necessarily import natural love and affection. Thus, where a Hindu husband, after referring to quarrels and disagreement between him and his wife, executed a registered document in favor of his wife, agreeing to pay for separate residence and maintenance, for it was held that the agreement was void for want of consideration because it was not made out of natural love and affection. Second, agreement to compensate for past voluntary service. A promise made without consideration is also valid if it is a promise to compensate wholly or in part. A person who has already voluntarily done something for the promisor or done something which the promisor was legally compellable to do. Illustration. First, A finds B's purse and gives it to him. B promises to give A rupees 50. This is a contract. Second, A supports B's infant son. B promises to pay A's expenses in so doing. This is a contract. Note that B was legally bound to support his infant son. Third, A rescued B from drowning in the river, and B, appreciating the service that has been rendered, promises to pay rupees 1000 to A. There is a contract between A and B. In order to attract this exception, it should be noted that the promise must be to compensate a person who has himself done something for the promisor and not to a person who has done nothing for the promisor. Thus, where B treated A during his illness but refused to accept payment from A, they being friends, and A in gratitude promises to pay rupees 1000 to B's son D, the agreement between A and D is void for want of consideration as it is not covered under the exception. Third, agreement to pay a time barred debt. Where there is an agreement made in a writing and signed by a debtor or by his authorized agent to pay wholly or in part a debt barred by the law of limitations, the agreement is valid even though it is not supported by any consideration. A time-barred debt cannot be recovered, and therefore a promise to repay such a debt is without consideration. Hence the importance of the present exception. But before the exceptions can apply, it is necessary that first, the debt must be such of which the creditor might have enforced payment but for the law for the limitation of suits. Second, the promisor himself must be liable for the debt, so a promissory note executed by a widow in her personal capacity in payment of time barred debt of her husband cannot be brought within the exception. Third, the promise must be in writing and signed by the debtor or his agent. An oral promise to pay a time-barred debt is unenforceable. The logic behind this exception is that by lapse of time the debt is not destroyed but only the remedy is lost. The remedy is revived by a new promise under the exception. Illustration: A owes rupees 1000 but the debt is barred by the Limitation Act. A signs a written promise to pay B rupees 500 on account of the debt. This is a contract. Fourth, completed gift. A gift which is not an agreement does not require consideration in order to be valid. As between the donor and the donee, any gift actually made will be valid and binding even though without consideration. In order to attract this exception, there need not be natural love and affection or nearness of relationship between the donor and the donee. The gift must, however, be complete. Fifth, contract of agency. Section 185 of the Contract Act lays that no consideration is necessary to create an agency. Seventh, contribution to charity. A promise to contribute to charity, though gratuitous, would be enforceable if, on the faith of the promised subscription, the promisee takes definite steps in furtherance of the object and undertakes a liability to the extent of liability incurred not exceeding the promised amount of subscription. In Kedarnath versus Gauri Muhammad, the defendant had agreed to subscribe rupees 100 towards the construction of a town hall at Howrah. The plaintiff, secretary of the town hall, on the faith of the promise, entrusted the work to a contractor and undertook liability to pay him. The defendant was held liable. But where the promisee had done nothing on the faith of the promise, a promised subscription is not legally recoverable. Accordingly, in Abdul Aziz versus Masum Ali, the defendant promised to subscribe rupees 500 to a fund started for rebuilding a mosque, but no steps had been taken to carry out the repairs. The defendant was held not liable and the suit was dismissed. It may thus be noted that consideration need not always be something in return. It may even take the form of some risk, loss or responsibility suffered or undertaken by one party. Test questions. First question. Define consideration. How far it is necessary for the validity of a contract. Critically discuss the essential elements of consideration. Second question. Explain the term consideration and state the exceptions to the rule no consideration, no contract. Third question. Insufficiency of consideration is immaterial. but an agreement without consideration is void. Explain. Fourth question. A stranger to a contract cannot sue. Discuss. Are there any exceptions to this rule? Fifth question. A stranger to the consideration can sue, but a stranger to contract cannot sue. Explain. Sixth question. Consideration need not be adequate, but it must have some value in the eye of law. Explain. And seventh question. No consideration, no contract. Explain. Practical problems. Attempt the following problems, giving reasons for your answers. First, M offered a reward to anyone who would rescue his wife, dead or alive, from a burning building. A fireman risking his life brought out the wife's dead body. Is he entitled to recover of the reward? Hint. Yes. In the instant case of fireman took an extra risk of endangering his life which does not fall in his normal duties in connection with rescue operations. As such, the consideration is not illusory and the fireman is entitled to reward. Second, A and B are friends. B treats A during A's illness. B does not accept payment from A for the treatment and A promises B's son X to pay him rupees 1000. A, being in poor circumstances, is unable to pay. X sues A for the money. Can X recover? Hint. No, X cannot recover the money from A. The agreement between X and A is not a contract in the absence of consideration. In this case, X's father, B, voluntarily treats A during his illness. Apparently, it is not a valid consideration because it is voluntary, whereas consideration to be valid must be given at the desire of the promisor. Wide section 2D. The question now is whether this case is covered by the exception given in section 25(2), which inter alia provides it is a promise to compensate a person who has already voluntarily done something for the promisor. Thus, as per the exception, the promised must be to compensate a person who has himself done something for the promisor and not to a person who has done nothing for the promisor. As B's son X, to whom the promise was made, did nothing for A, so A's promise is not enforceable even under the exception. Third, X is a social reformer, promised Y a reward of rupees 1000 if he refrained from smoking for 2 years. Y does so. Is he entitled to the reward? Hint. Yes, Y is entitled to the reward from X. In the instant case, Y, at the desire of X, refrained from smoking for 2 years. This is a valid consideration in the form of an act of abstinence. Wide section 2D. Fourth, A writes to B, at the risk of your life, you saved me from a serious motor accident. I promise to pay you rupees 1000. A does not pay. Advise B as to his legal rights. Hint. B is advised to file a suit for recovery for rupees 1000 under section 25(2) of the Contract Act. A promise to compensate for voluntary acts done in the past is valid even though without consideration, as the instant case is fully covered by the above section. A cannot avoid his liability later on. And sixth, for a valid consideration from B, A makes a promise to B that he would coach C in the month of March. C sues A on the promise. Discuss whether he can succeed. Hint. C cannot succeed. The general rule of law is that a stranger to a contract cannot sue. In the instant case, C is not a party in the contract and there